All right, friends, come on a decarbonization side quest with me to look at an issue that actually just came up the other day. So we're calling it tenant-owned assets, and my clever subtitle is not your asset, but your problem. So what's the issue here? What am I talking about? States like Washington, there's lots of different compliance pathways, but generally speaking, buildings have to be benchmarked. There needs to be an operations and maintenance program and an energy management plan. That's part of that program. We start talking in acronyms and it's very annoying, but here we are. So the issue is all equipment has to be included in both the O&M program and the EMP, regardless of whether it's owned by the tenant. These are compliance documents. Owners can't just omit equipment saying, hey, the tenant owns it. It's not our responsibility. This actually came up during our Department of Commerce hosts office hours, which are a super helpful opportunity to ask questions and things like that. And the sort of examples that were given when we were looking at the requirements of an energy management plan specifically, where they have to have a brief description of building systems, including envelope, hot water, HVAC, commercial refrigeration, and things like that. So the examples that folks in the audience were giving were water heaters or walk-in refrigeration units that might be owned by the tenant in like a commercial kitchen kind of context or restaurants. And owners don't have any control over those, how they're operated, how they're maintained, how they're replaced, and things like that. But again, not your asset, but still your problem if it falls within the purview of the documents that the owner is legally required to submit to Department of Commerce. So drilling down on those requirements a little bit further, our Department of Commerce also provides sort of a template tool for what those documents should look like. And I pulled a screen grab of the specific sections that are relevant to this issue. So that first block of text is basically what I just read, sort of those requirements. But then owners also have to verify that they have safe and reasonable access to all equipment covered by the O&M program for inspection, maintenance, and repairs. How are you going to do that as an owner unless you reserve that right in a lease? Because again, if you've heard me in any of my videos ad nauseum, I talk about how the lease is the contract that governs the owner-tenant relationship, and building performance standards have forever altered how that relationship is going to be way more collaborative moving forward. So you've got to attest to these things. How are you going to reserve those rights? You're going to do it in a lease, and I'll give some examples in a minute. And then the second block, or the third, excuse me, block of text, O&M requirements are reevaluated when building use changes. If you've watched any of my prior videos, use of premises is a huge aspect that needs to be covered in leases and building performance standard jurisdictions, or renovations or alterations that affect the facility's operations. So that's going to include tenant improvements. That's why TI provisions are really important in leases in BPS jurisdictions. So, and that's sort of addressed in this, I guess, fourth or section 6.5 that they have here. So, and then there's this example as well. This is from the template for the energy management plan, kind of similar language as well. So the sort of answer that was given to that question was all equipment has to be included in the O&M and the EMP, regardless of whether it's owned and operated by a tenant. There's no provision that owners can just omit equipment based on tenant ownership. So I took a look at some of the template leases that I've seen and used and the industry, sort of accepts. And access clauses are really vague in general, and they don't cover this type of situation, again, because it has never been contemplated before that an owner would have or have any reason to or even want to have control or access over tenant-owned equipment. This is a pretty standard access provision, reserves the rights to various things, including to enter the premises at any reasonable time for inspection or any time in the event of an emergency. Pretty broad, doesn't cover those specific aspects. So what are some of the things you want to consider in a BPS lease to address this not your asset, still your problem issue? Anything related to BPS compliance, including kind of, I would mirror that language, ability to access, inspect, and repair tenant-owned operated equipment. That's going to get a little bit sticky because who's going to pay for costs? Are tenants actually going to want owners in there? Are owners going to want you going in there? You're going to have to at least have some type of ability to review those things under the requirements under the O&M and the EMP. Probably some type of reasonable notice provision. I saw the example in this pretty standard lease up here, but might want to describe a little bit more clearly what reasonable is. Business day, written notice, whatever it is, whatever makes sense for the context. And then the ability to make reasonable operating adjustments if needed. Sort of the conversation again in office hours was related to what if a tenant is operating this equipment on a schedule that's not necessary, like 24 hours a day, and maybe it only needs to be running for 12 hours a day or when the business is open, or not maintaining it in such a way such that it's using additional utilities and things like that. So again, going to get a little bit tricky here, but owners may need to make some reserve the ability to make some reasonable adjustments. This again gets to use clauses where I talk about owners potentially having to limit tenant use or at least know about it, or use changes in their lease provisions as well. So those really broad kind of access clauses really aren't going to cut it in BPS jurisdictions where owners have the legal obligation and requirement to submit these documents, O&M and EMP, and they have to sort of verify these things or make sure that they're able to comply. So tricky new stuff. Building performance standard jurisdictions building performance standards are key decarbonization tools. They have altered the owner-tenant relationship and really forced this collaboration. That's a good thing. And leases, as the document that governs the owner-tenant relationship, also need to change in order to kind of make these processes make sense and make them workable. So very curious to hear how other folks are handling these issues, if they're coming up, what kind of conversations you're having, how you're managing them. If my suggestions related to lease provisions make sense. We help clients with this kind of stuff all the time. So reach out if you have questions or concerns, or if you have ideas on how you're managing these on your building. So let's keep decarbonizing. Thanks for coming on the side quest with me.